Well, I think we'll get started here. Welcome, everyone. Good afternoon. My name is Natalie. I'm the event manager at Employment Hero, and I'm really excited to be joined today by Stuart Dukoff, founder of E2R and one of Canada's leading employment and labor lawyers. Stuart built E2R around a powerful idea, providing real-time, unlimited HR and employment law support that aligns directly with the business's priorities. Their team is known for their urgency, practicality, and ability to deliver real advice in real time, every time. With more than 3 decades of experience, Stewart has helped employers navigate compliance, human rights matters, contracts, mergers, acquisitions, and complex litigation. He's also a trusted advisor to major Canadian companies and a sought-after voice for media and industry groups nationwide. We're very thrilled to have him here today. Please join me in welcoming Stuart. Stuart, I will hand it over to you.
Thanks, Natalie, and thanks for those kind words. Um, what we're talking about today, of course, is ushering in 2026, and that is remarkable in and of itself. Just so you know, it had nothing to do with it. It is occurring on its own volition. But our subject today certainly relates to legislative change, certainly in part, and it reminds me, my then 12-year-old son, which wasn't all that long ago, he's a PlayStation Madden football enthusiast, to say the least. And so he absolutely enjoys the prospect, particularly of playing the Buffalo Bills on PlayStation, because he knows he will beat them, and he knows the Bills are one of my favorite teams. So before the last game where he was going to pick on the Bills once again, as a 12-year-old, it was rather remarkable. What he said was, Dad, as sure as death and taxes, the Bills will fumble the ball again in my game and lose. And it reminded me, I guess, to some extent, of the challenges employers face because the legislation, albeit not death and taxes, as it were, always adds another level of burden, as it were, for employers. So there's always that additional challenge. And for those of you in Ontario, although there's similar type legislation evolving elsewhere, you need to pay attention because January 1st, there's some pretty material changes under the employment standards legislation. So in addition to that, well, we'll be talking about in that context the AI disclosure requirements for job postings. That's one of the requirements. There are now requirements when you recruit in job posts publicly that you have to identify the compensation, or at least the range in compensation for that position. So we'll be talking about that. Obviously, we only have a short period of time together. And so we'll discuss that. We'll also talk about termination clause enforceability. All of you, hopefully, have your employees enter into employment agreements. Unfortunately, particularly in Ontario, Ontario, um, that's not necessarily good enough because you better have drafted your termination provision appropriately. Otherwise, there are dire consequences attached to that. And then we'll sort of end in the shortness of time, just looking ahead to 2026. And we got to go, okay, when are the stat holidays? What about vacation pay? Am I calculating vacation pay properly? And then ultimately about policies. And should we be paying attention to ensuring they're current? So yes, we have limited time together, but let's see what we can accomplish together. So let's go to the next slide and talk about recruitment and Ontario's employment standards legislation. So for those of you in Ontario, the Workers for Workers Act 4, as it were, seems to be forever ago as we build more numbers into it, 5, 6, 7, etc., in terms of the ongoing changes to the employment standards legislation. But from a recruitment perspective, what you need to know, certainly from a threshold perspective, is that if you employ 25 employees or more at the time of the public job posting, then these amendments to the legislation apply to you. And one of those certainly amendments is the obligation to disclose the use of AI, right? And AI, of course, is no surprise, very broadly defined in the legislation. I can take you through that definition, but I'll tell you, for me, my eyes gloss over because it seems like it's almost anything. So if you're using tools from a recruitment perspective and there's any AI as part of that, well, then you have to disclose. But what are you disclosing? So take a look. What it says is, as of January 1st, 2026, these employers must include a statement on the public job posting if AI is used to screen, assess, or select. So one of those three, two of those three, three of those three, you've got to disclose. Now, most employers are simply going to identify that we rely on AI and that AI may be used in part to screen, assess, or select, and leave it at that. Less is more, right? There's no requirement to go beyond that currently in the legislation. As regulations ultimately are promulgated down the line, maybe there'll be more, but as of the moment, no. Okay? So in terms of that requirement, then you've got to make sure it's on your public job posting. And just for fun, because it's just too much fun, let me define, or as set out in the legislation, what AI is. A machine-based system that, for explicit or implicit objectives, infers from the input it receives in order to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Did everybody get that? I'm sure everybody got that. So the point is, though, it's wide in scope. Okay? All right, let's go to the next slide where we get to see what I just told you, but I wanted you to hear it orally first to recognize how expansive it is, but there it is in front of you. All right, so very broadly defined. All right, but what's a public advertised job posting? Let's go back. Sorry, did I hit just go back to the slide before, Natalie? Okay, so the publicly advertised job posting. So what is it? Because remember, we're only talking about that, right? So the publicly advertised job posting doesn't include internal job postings, right? It doesn't include general help wanted signs. And I'll give you the detail on this, the recruitment for work performed outside Ontario, there's actually an or it's performed outside Ontario and in Ontario, and the work performed outside Ontario is not a continuation of the work performed in Ontario. So there are exceptions, or there's a better way to describe it. There's a definition of publicly advertised job posting. So what are the two things we know so far? 25 employees or more as of the time of the publicly advertised job posting, and the publicly advertised job posting is not, in essence, let's call it internal postings, general help wanted signs, and recruitment for work performed outside Ontario or in and out if the outside Ontario is not a continuation of inside Ontario. Okay, so that's the setting that we've got so far going forward. All right, let's go to the next slide. All right. Now, in that publicly advertised job posting, you now have to set out the compensation or the range of expected compensation. Okay, now, just to stop for a second, let's think about a potential problem associated with that. You have an existing employees that are in that position. They, of course, have the opportunity and indeed may see that publicly advertised job posting that now has compensation that exceeds their own. And from a recruitment standpoint, as employers are well aware, the market is such at various times where you're going to have to offer more favorable compensation to attract employees in the market. And that compensation that you're paying for the new recruit, as it were, may be higher than the existing employee. So now there's transparency to some degree now. So you have to anticipate that problem. All right, let's go back to what you have to disclose. So it's the compensation you're disclosing or the range of expected compensation. So take a look, and that range can't exceed $50,000. So the example we show there is $75,000 to $125,000. So the job we're posting for has a range of $75,000 to $125,000. Okay, fairly significant range, as it were, but it's not applicable. So there is an exemption. It's not applicable to a position that pays more than $200,000 or has a range where the end of the range is expected to be $200,000 or more than $200,000. All right. So in that case, you have no requirement to set up the compensation. Okay. But bear in mind now, you've got this form of transparency now where everybody is going to see what this position, or at least the range for this position. And that could create some discomfort depending on the employer's circumstance. So just be mindful of it so you're anticipating how you may respond to, let's call it, queries, certainly in my example, from existing employees. Okay, what else is going on with the changes to the Employment Standards Act? Well, as you see listed there, employers, effective January 1, are now prohibited from including requirements related to Canadian experience. Right? So you can't ask for Canadian experience anymore. That's pretty self-evident in terms of what that prohibition is all about. Okay, let's go to the next slide. All right. Existing vacancies. So you have to identify now, you have to have a statement in that publicly advertised job posting, disclosing whether the posting is for an existing position or not. As some of you may have done in the past, and some people have an unfavorable view of it, others don't. That sometimes you want to see what's out in the market. So you don't have an existing vacancy, but you publicly advertise to see who's out there, right? And maybe keep those resumes on file because you anticipate down the road, but you're not in a position right now to say, oh, we have a vacancy. Well, now you have to disclose. You have to disclose whether it's for an existing vacancy or not. Now, is the consequence of that given the perspective that that's not a favorable sort of corporate step to take or strategy, so many employers who formally did that will elect no longer to do it because they don't want to say it's not for an existing vacancy? That may happen. We'll see what happens down the road. Okay, what else is going on with the changes to recruitment under the employment standards legislation in Ontario? Post-interview communication. So now you're required within 45 days of the last interview to let that candidate know if a decision has been made regarding the hiring. So probably many of you have a protocol where you're certainly informing candidates that they're no longer being considered or what have you. But now certainly you've got a legislative requirement that says you've got to let them know if a hiring decision was made. And it's from the last interview. Now, what's an interview, you ask? Well, let's, for fun, take a look at the definition of what an interview. Interview is defined as a meeting in person or a meeting using technology, including but not limited to teleconference and video conference technology between an applicant who has applied to a publicly advertised job posting and an employer or a person acting on behalf of an employer. Note that person acting on behalf of an employer. And by the way, that person acting on behalf of an employer, if they fail to do, so we're talking about what you have to include in a public job posting. Let's say you're using a recruitment agency and they don't put the compensation range in. Well, employer, you're on the hook for that contravention, even though that notional third-party recruitment agency you've engaged failed to do what they need to do. It's on you, though, employer. So same idea here. And an employer or person acting on behalf of an employer where questions are asked and answers are given to assess the applicant's suitability for the position, but does not include preliminary screening before the selection of applicants for such a meeting. So just for purposes of clarity, the definition of interview includes, hey, listen, the vetting process doesn't, it's not an interview. But once you have that interview, yes, you're subject to this time frame for letting the candidates know. Okay, we're not done. There's more. Record retention. All right, so now the Act says that you've got to keep every publicly advertised job posting and any associated application forms for 3 years after access to the posting by the general public is removed. So just call it 3 years. And by the way, it also includes any information that you've shared with the interviewed applicants. Okay, now this question has come up previously about notes. It doesn't, if you've got notes, that would not presumably be information you provided to the applicant. So you're not sharing those notes. There's no obligation to share those notes. And in terms of any retention of those notes, by the way, it's a good idea, of course, to retain those notes because, of course, any declined applicant could, for example, say, oh, you discriminated against me on the basis of my age. That's why you didn't hire. Well, if we have notes from those interviews that identify, our concerns regarding technical skill, perhaps even, some thoughts on how they responded in the context of the interview, that wasn't the type of person we were looking for. That's all fine. And that you would use in support of your position. That age, of course, had nothing to do with it, and therefore refute that allegation. So record retention now also forms an important part of these legislative requirements. Okay, let's also go on now to the next slide where we're going to talk about the developments in the courts regarding termination provisions and employment agreements. So just as a general statement, this applies all across Canada. That you have to meet the minimum standards, and typically this relates to termination provisions in employment agreements, that you have to meet the minimum standards of your jurisdiction. If you fail to, in the drafting of the termination provision, not what you ultimately did factually, the court doesn't care if you ultimately paid the person in accordance with the contractual requirement and the minimum standards legislation in your jurisdiction. They don't care. They care about the drafting of the contract. If that termination provision is not drafted properly, it's as though it's not there. And if it's not there, then many of you are probably aware you have this whole big common law obligation to provide reasonable notice, which essentially has been goes up in Ontario, you're up to about 30 months. And now that's happening outside in Alberta as well now. I think you're up to 26, 27 months in Alberta. So it's a big, big, big number for long service employees if you fail to draft it properly. All right. All right. So so once again, the key consideration in determining whether your termination provision that you incorporated in your employees' employment agreements is enforceable is if it meets the minimum standards requirements for termination. And in Ontario, you have termination and severance pay. Federally, you have severance pay as well. So just make sure you meet those minimum requirements. Okay, let's go to the next slide and talk about the Ontario adventure. Okay, it's an adventure because it's truly an adventure. If we had background music, we could put this to background music and I could actually sound remotely interesting regarding this material. But here we go. All right. So Waxdale versus Swagon, North America. It's referred to as the Waxdale decision. So why is that relevant? Well, it's a Court of Appeal decision in Ontario, and it stands in essence for the proposition that, all right, think of this. You're terminating somebody on a without cause basis. How many of you terminate employees in your organization on a with cause basis? That rarely ever happens, right? You're always terminating everybody on a without cause basis. Okay, right. So what did Waxdale? It stands for the proposition that if you've got a with cause provision, which you probably do in your termination provision, and that with cause provision fails to meet the minimum standards. So in the Waxdale case, what do you think the employer said? Well, court, why are we even talking about the with cause provision? We terminated on a without cause basis. So what? The court said, oh, no, we don't care. You've got termination provisions have to be considered as a package. Okay? Has to be considered as a package. And if one part of that package is unenforceable, it taints the entirety of that whole package. So the with cause provision in that employment agreement Mr. Waxdale was subject to, it didn't meet the minimum standards in Ontario. And the minimum standards in Ontario is willful misconduct, willful neglect of duty, willful disobedience. That's a different test than cause. So the court said, you didn't meet that minimum standard. Remember, we just talked about it moments ago? And Supreme Court of Canada said unequivocally, well, you don't meet the minimum standard. It's not going to be enforceable. So that was it. Provision gone. Mr. Waxdale's entitled to common law reasonable notice. Okay. All right. We got to learn from our mistakes, as it were, as they say. So we go from there, and then the employers say, okay, we got this. We're going to draft our with cause provisions so they're perfect. So they don't fail to meet the minimum standard. Okay. Then we enter Defoe and the Corporation of the Township of Ignace and Baker versus Vandal Older's home team. All right. So what happens here? So in these provisions, in the without cause provisions, in both cases, in essence, the employer put in the employment agreement, no surprise, we can terminate you at any time. But here's what we'll give you when we terminate you. Well, what? Of course, we can terminate you as an employer at any time. No, says the court. Court says, no, you can't at any time. Why? Because any time might mean, for example, you're going to terminate somebody while they're on a maternity leave. To which the employers in both cases are going, what? You're assuming we would violate any time you're interpreting as us assuming in effect that we're going to violate the employment standards legislation as it relates to statutory leaves of absence? Answer, yes. So the court said, if you've got any time in there, that means your language permits a termination during a statutory leave. You can't do that. Therefore, it falls. Therefore, boom. We don't have a termination provision anymore. Okay. All right. Okay, we got this. No anytime. Okay, we got that. We're not going to do that. We're not going to make that mistake. right, at all. And we're going to make sure our for-cause provision reflects the minimum standard, certainly in Ontario, willful misconduct, willful disobedience, willful neglect of duty. Okay, we got this. We got this. Okay, probationary employees, there's not a problem, right? Of course, we can say for terminate at any time as it relates to a probationary employee, to which the answer is no. To which the answer is no. And what happened in Chan, I'm going to sort of read out, it's a very short provision. The first 3 months of your employment are probationary, right? Most of you have that, right? Your employment agreements, during which time, okay, the company may terminate your employment at any time and for any reason at its discretion. Yeah, okay, well, the point is we're evaluating suitability during the first 3 months, so we want to terminate those that are not suitable for our environment. That's the whole idea. And it goes on to say without notice or pay in lieu of notice or other obligation. Kind of a standard form. At any time and for any reason at its discretion was determined to be, once again, this idea that you could terminate when somebody is entitled to a statutory leave of absence. So probationary period falls, and Mr. Chan actually got a pretty darn good severance, even though he was very short service. So we're in this situation. By the way, Dufo and Baker are going to the Court of Appeal in actually next month, I believe. So we'll see if those decisions are upheld as it relates to the anytime aspect. We'll see what happens. Now, BC and Alberta, not the same approach in BC and Alberta. There's reason to believe they're not going to go the Ontario way. And in fact, there's a decision out of BC, Egan and Harbour Seaplanes, where the court said this, and I think it's for counsel that acts on behalf of employers. It's comforting sometimes to get language like this, where the court said, look, they stated that proper contractual interpretation is not accomplished by disaggregating the words in a termination clause as a way to find the clause was unenforceable. So it's almost like we're not going to go into this to try to find it to be unenforceable and disaggregate the words accordingly. We're not going to do that. So that's where we are. Ontario, BC, Alberta, different approaches. As of now, we'll see what happens. Ontario, there may be a little bit of a change early in the year. We'll see what happens. Okay, next slide, please. Okay, so as the holidays approach, of course, our minds are to some degree on statutory holidays. So at the end of every year, it's good to look forward and say, okay, when are these dates? Are they on working days? Are they on non-working days? And what are the options, right, as it relates to if they're on working day, non-working day? So as you see, one of these options, of course, is substitute holidays, right? And, using Ontario, although electronic agreements and things like that. But ultimately, you can do a substitute holiday typically within 3 months. If you have the electronic agreement of the employee, you can schedule it within 12 months. But the point is not specific detail for this purpose. It's more about take a look and see what your options are as to what you're going to do. And maybe you will do a substitute holiday, maybe you won't, but decide what you're going to do. So look out at your calendar going forward to make sure you've got that. And then you should publish it, right? So that everybody knows how you're going to approach your stat holidays in 2026. Okay, so it's just a nice thing to do to make sure you're prepared proactively on a go-forward basis. Okay, let's take a look at everybody's favorite vacation. Usually a topic, and it's very funny. You would never have predicted this as a young lawyer, HR practitioner, looking at all the plethora of matters that you have to deal with on an ongoing basis. You would never think vacation is often the most challenging. And that's because of employment standards legislation. It's very difficult sometimes to interpret and apply the employment standards requirements versus what happens contractually and from a practice standpoint with the employer. So there's sometimes very challenging questions as it relates to vacation. And sometimes one of those challenging questions is, well, I know, yeah, I have 4%. Yeah, I go, okay, I got that. And we're supposed to be 6%, depending on where you are after 5 years, it goes to 6%, 3 weeks. Okay, got that. But what are we paying that percentage on? What are the earnings? And as you see in that first sort of chart on the left, square on the left, what vacation pay applies to? It's easy, the base salary part, but I can tell you, been in this space for a gazillion years, employer after employer after employer fail to include commissions, and you see listed there, bonuses. Those are vacationable earnings. Doesn't matter that you pay them towards the end of the year or whatever the sequencing is. Those are earnings upon which you owe vacation. So you've got to make sure you reconcile that so that they're properly paid out. So as you see listed there, commissions, work-related non-discretionary bonuses. If they're work-related, whether it's hours of work, productivity, whatever it is, that's the criteria for entitlement, well, that's vacationable earnings, right? And you see at the bottom, $1,000 performance bonus tied to hitting a sales target. Well, yeah, right? Now, in some jurisdictions, you've got a few exemptions. I've always loved this fun one. It's been there forever. In some, certainly in Ontario, commission-based salespersons are exempt. But it's those who, as you see there listed, earn commission on sales made away from the employer's premises. So, this was drafted in yesteryear, right? When, physically you'd go out to the client, you do the paperwork at the client's location, and nobody has a real track on what you're doing. You're kind of on your own time as a salesperson. So that's why vacation didn't apply. It still doesn't. But it's gotten a little bit more difficult to determine whether they fit within that exemption. As you might expect with all exemptions under employment standards legislation, it's very narrowly construed. All right. Now, on the bonus side, as you see there, the Christmas bonus given to all employees, regardless of performance, doesn't require vacation pay. Right? So it's given to everybody. It doesn't matter what your performance is. We just give it out, the Christmas turkey. Wasn't it on, oh gosh, I can't believe I forget the name of the store at Bathurst and Bloor. Not Sam's. It was, I can't remember the name, but they used to, I think, line up for the turkeys and give the turkeys away. That wouldn't be vacation pay on the turkey. And some commission exemptions may also apply, right, depending on the province. So you always have to look at what jurisdiction you're in to take a good peek to make sure as to whether the vacation pay is being properly calculated. Okay, so with that all said, let's take a look at employment policies now as a sort of a last, just concluding topic. I'm just going to keep it brief in that regard, but just note that as a general statement, your employee handbooks, if I can step back for a moment, there are two fundamental infrastructure deliverables that you have to have in HR. You have to have employment agreements. We talked about some of the consequences attached to having an employment agreement that's not properly drafted, and they are significant. And then also employee handbooks, because your employee handbook is going to set out a whole variety of policies that are applicable to managing HR properly. Right? Anything from expenses, travel, codes of conduct, attendance management, you name it. Right? In fact, I was just talking today about a situation where how long are we going to maintain benefit enrollment for an employee who's on disability now for an extended period of time? In our employee handbooks that we draft, we typically set out a time frame within which the employee is going to have to assume the cost of those premiums going forward, because they're unfortunately in a position where they're no longer contributing. But there's a clear policy identifying that, so you can rely on that as an employer. So as a general statement, take a look at your employee handbooks, make sure they're current on an ongoing basis. Do you have new current internal protocols that are not reflected in that? And of course, legislative. change, which, as you know, is at a very rapid pace. And also, you want to take a look at things like, for example, your harassment policy from a occupational health and safety perspective, from a OSHA, the legislative perspective, certainly in Ontario, and in other jurisdictions as well. You have to make sure you're reviewing and revising it at least annually. So that's a legislative requirement, right? So there's just from a best practice standpoint, you should be looking at your policies on an ongoing basis. Certainly, certainly on an annualized basis, you should have your employees sign off on it. Certainly, as it relates to changes, new policies, revised policies, that can be very valuable. I can tell you when you litigate those scenarios, if you have an employee who signed off on a policy and that employee has failed to comply with that policy, you're relying on that failure ultimately perhaps to terminate, maybe for cause or willful misconduct. It is very valuable to have that sign off because the court's looking for it. They want to be comforted in knowing the employee had the opportunity to see it, confirm they had the opportunity to see it. So how can they allege they didn't know about it? Or there was a misunderstanding. Pretty tough for the employee to take that position. So all to say, make sure you're taking a look at it. It's a good time of year now to think about it. We're at the end of the year, looking forward into 2026. So now's the time. It's a good time. So I think with that, Honest Eds, I just looking up. Thank you. Oh, thank you, Honest Eds. That's it. The turkey, right? That's a sad loss for Toronto, I have to say. And I'm a former Montrealer, so I mean, this Honest Eds and the turkey, that was great. And I don't know if there's anywhere else that does that I'm aware of, but that's great. Okay, so Natalie, I think I've my welcome. So if there's any questions,
Yeah, we've
happy.
quite a few. I'm going to go through them between the chat. I see some in the chat and then as well as in the Q&A box. So I will just go through and read those to you. Um, so there was a question, and I'm not sure if you would have the answer, but does LinkedIn auto archiving someone outside of Canada, or putting 3 years of experience when your requirement is 5 count as use of AI?
I don't know the answer to that LinkedIn, but once again, when you saw that wide definition,
Yeah.
I don't know the answer, but given how broad that definition is as to what it incorporates AI, you want to
Yeah.
take a look at it or ask some questions, certainly. So I would say that. So I don't want to comment on that because I don't know.
Maybe.
But all I will say is it's probably appropriate to ask some questions.
Yeah.
And by the way, even if you err on the side of being overly cautious, um, most candidates, um, it's not going to be all that meaningful when you disclose that you've relied on AI in part. It could for some, and some of you may indeed be aware, there's a major class action lawsuit in the U.S. Where allegedly, believe it or not, 1 billion members in the class that have been declined jobs by virtue of at least the representative plaintiff is alleging he was discriminated on the basis of age by a tool that was used by 80 different or 100 different employers that he applied to. And he says that tool used by all of them discriminated against him on the basis of his age. That's his claim. So yes, there's this sense that the tool, if it's not a reputable tool, or even if it is, we're at the early stages and it still may not by intention, but unfortunately by just design at the current where we are currently, may unintentionally discriminate. So that's obviously the inspiration for disclosing it. But as a general statement, at least at this stage, hopefully there's not that many candidates as soon as they see it going, oh, I must have been discriminated against.
Right.
Right? Hopefully that's not what happens. But yeah, to be honest, because certainly I'm aware of the US based class action, one of the big ones. Um, is it a possibility as soon as you disclose it, a declined candidate says, aha, it must be because I am, pick the prohibited ground of discrimination under human rights legislation,
Right.
right? So, yeah, it's a possibility.
Thanks. Um, a question regarding posting the salary and salary transparency. If the position includes commission, does that need to be included in the range or just the base salary?
No, it's going to have to be all comp. So yes, so you're going to have to what the anticipated commission income might be. Um, sure, it's difficult to anticipate what that might be, but if there's a history from a territorial standpoint, for example, but now you may be adjusting territories or what have you. But the idea is yes, to include what the anticipated earnings are going to be.
Okay. Do owners count towards the 25 employee threshold?
No, I would say it's a good question. Typically, the directing mind of an employer is not considered an employee. Um, Now, of course, if I'm the sole shareholder, probably don't have an employment agreement, although you could with the company. So yes, technically, are you a shareholder and an employee? Yes, you're both. But you're the directing mind, right? So you're not typically considered to be an employee if you are in a position to make those kinds of decisions as the directing mind of the organization. So the general answer, and of course, a lawyer, I think you may have already heard me speak for 45 minutes where I haven't used the word depends yet. So I take credit for having waited this long to say that. So it will depend, but as a general statement, I think that's valid. If you're the directing mind, you're not going to be uh, characterized as an employee.
Okay, great. There was a question, what if our new hire negotiates a full compensation package greater than the amount advertised? Is there
Oh, that's
anything?
a great question. Well, you can't retroactively. That was the intention. The legislation doesn't say the candidate can't negotiate something over and above that range. Um, so, so I'd say, using the example of um, you've got the $50,000 range and somebody negotiates more than that. Um, Good on them. So yeah, so I don't think that's an issue. The expectation is you're going to pay that. It doesn't mean legally you're limited to paying that. It just means you have to, from a transparency standpoint, put it in your public job posting. But if the ultimate negotiation leads to something in excess of that or even less, I guess,
Mhm.
um, fine, right?
Yeah. What if the job is posted Canada-wide, not Ontario specific? Um, would you need to abide by all province rules? Does like,
Well, remember what we talked about, and I'm going to just pull up just so I say it properly. If the job posting is for work in Ontario, then it has to meet the requirements. And of course, you have 25 employees, right? So it has to meet, and it's right. So it's for work performed in Ontario. Sorry, the exemption is for work performed. So publicly advertised job postings does not apply to recruitment for work performed outside Ontario or performed outside Ontario and in Ontario. So you can still have work performed in Ontario. And the work performed outside Ontario is not a continuation of work performed in Ontario. So that's the exemption. Outside Ontario and uh, and performed outside and inside Ontario, but the work outside Ontario is performed outside and inside. If the work performed outside Ontario is not a continuation of the work performed inside Ontario. So those are sort of the two exemptions. As to, if you're hiring, of course, in Saskatchewan, well, local Saskatchewan legislation will have application, right? To the extent there is any applicable legislation affecting the recruitment process, right? But it's if I use Saskatchewan as an example, I'm hiring somebody in Saskatchewan, so that's work performed outside Ontario. Therefore, these job posting requirements don't apply.
Okay,
Simple as that.
great.
And I'm not sure I can say simple as that too often, but when I can,
Yeah.
I'll say it.
Yeah. Um, is it advisable to have each of your policies separately signed by the employee, or is it satisfactory to have all the employees in an employee handbook that they acknowledge and sign?
It's a good question. Our practice often is to, yes, you have an acknowledgement, well, a signing one, as they've had the opportunity to review the entire employee handbook, but sometimes you pull out specific provisions, like a violence and harassment policy, right? That you might want a more directed acknowledgement that they've reviewed it and, of course, agreed to the terms. So, yeah, don't be afraid to pull out a few of the more important policies. It doesn't mean the others, of course, they're not agreeing to, but you're directing their minds specifically to these, more fundamental policies, and they're specifically identifying that they've had the opportunity to look at those. There's nothing wrong with doing that. And it has a nice optic to it as well as an employer, that not only are you just kind of routinely having them sign off, but you're saying, look, we want to make sure you really understand our progressive discipline policy, our violence and harassment policy, right? Whatever it is, we want to make sure you really understand it. So yes.
Okay, great. There is a question about vacation. Um, how, or do you have any advice on how companies handle the disruption when someone comes back from a mat leave, but then they want to use 25 unpaid vacation days plus 25 paid vacation days within a year?
Okay, we'd have to, that's one of those. Look, as a general statement, remember I talked about vacation, how it can be very difficult to administer. So as a general statement, I mean, let's look at vacation time. The fact that you were on mat leave, so what? You're an employee throughout that period of time, you accrued vacation entitlement, vacation time entitlement. As to vacation pay, from an employment standards perspective, typically you haven't earned anything. Vacation pay is, look in the rearview mirror, is paid on the prior, let's call it 12-month period. You didn't work, there's no vacation pay payable, but you get the vacation time. Okay. But then you interpose the contractual. And I think that question said, do I have 25 days of vacation pay available to me? Well, if I'm entitled to vacation time and I have an accrued vacation pay pursuant to my contractual entitlement, probably entitled to it. Now, is there a discretion in the employer as to when you schedule a vacation? Typically there is. But you want to make sure you're not denying it simply on the basis somebody took an 18-month maternity parental leave period, because then it appears as though that you are singling out that person for having utilized a statutory leaves in this case, maternity and parental, and then saying, we think it's too long. I can't believe you're coming back after 18 months. I love it when somebody tries to say, you've been on vacation for 18 months. Yeah, go tell that to a mother who's been through the maternity leave and the parental leave and call that a vacation. Good luck if you survive that one. And then you want to take vacation, right? So I get it. I mean, I understand the employer perspective that says, really? But you want to make sure that if you are going to deny it, there's an operational reason for that denial. Make sure it's legit. That's all.
Okay. There were a few questions earlier in our session. I'm not quite sure how to pinpoint what it was referring to, but since it was earlier, I can only imagine it was perhaps about the salary transparency, etc. Um, does that specifically for full-time employees, does it affect independent contractors
Oh,
or that?
good question. Okay. So the age-old question as to the exclusion of employment standards requirements as it relates to an independent contractor. Okay, so the short answer is if you're an independent contractor in law, you're not an employee. The Employment Standards Act doesn't apply.
Mm.
All right. With the major asterisks, it couldn't be bigger, that in the vast majority of circumstances where an individual and the organization are characterizing their relationship as an independent contractual relationship, and they even have a lovely contract that sets out the independent contractual relationship and all the bells and whistles attached to that you should have, by the way. In most of those situations, they're still ultimately an employee. And we don't have the time to go through all the reasons why, but ultimately, I'll share the secret with you. There are 150, 200 criteria that courts, tribunals, government agencies apply to determine independent contractor versus employee. But it really all distills down to one fundamental principle, which is this individual truly in business for themselves? And we all intuitively know what it means to be running your own business. And if they're not doing that, do they have their website? Do they have an accountant? Do they have a lawyer? Right? List goes on as what you would need to do. Do they have financing from a financial institution? If they don't have any of that, then they're probably an employee in law, and therefore, employment standards legislation has application. Simple as that. And funny, actually, in our independent contractor agreements, just by way of note, we incorporate a provision in there that says, look, if this relationship is determined by a court to be an employment, then if we, as the organization, terminate the independent contractor, we're limited to minimum standards legislation. So we don't have to pay anymore. Because remember, if they're considered to be an employee and there's a termination provision that just says 30 days notice, you're gone, like most independent contractor agreements, or 2 weeks, you're gone, whatever it is, that's not going to be enforceable. So now they're entitled to common law. So we want to make sure we cover that potential that even though both parties want it to be characterized as an independent contractual relationship, if ultimately the court or whomever determines it's not, at least we built in this sort of fail-safe provision.
Okay. Is profit sharing a vacationable bonus?
But I would think the short answer, well, it's going to be a bonus, right? It's not going to be, I'm just looking at the list from the Ministry of Labor. Um, I, yes, I think the short answer is going to be yes, because how are you treating it? When you say calling it profit sharing, it's employment income, right? We're not talking about it's a stock option award or anything like that. It's earnings. So if it's earnings, and earnings include, right, regular earnings, commissions, bonuses, and really profit sharing, right? Profit sharing is another word for a bonus, right? Because many bonuses are calculated on the basis of profits, right? It's just another way maybe of calculating the bonus and calling it profit sharing. But ultimately it's a bonus, right? It's not a dividend on shares. So it's not, right? So it most cases it's just going to be another way of calculating what is otherwise really a bonus. So yeah.
Okay. Brittany asked, her organization requires secret clearance with GOC, which means they have to hire people who have lived in Canada for 10 years. How, if you know, how do you recommend they move forward with selecting applicants or making that known in the job posting? Would that fall under the, Canada
And you
experience
mean
separate?
no Canadian experience, I mean Canadian experience.
Yeah.
So sorry, you have to have 10 years. What is it? The
Because they
requirement?
lived in Canada for 10 years.
Well, living in Canada, it's a good question. Living in Canada versus Canadian experience, maybe two different things. And obviously, in order to identify to an app and a public job posting, you have to be eligible to work in Canada. Well, right? You still have to be eligible to work in Canada. So you have to immigrate from an immigration perspective. You would have to meet those requirements to work, right? So this idea of that you can't ask for Canadian experience, well, yeah, okay. I'm not asking for your Canadian experience in that position or in that business activity. I'm not asking for that, but I do need, because of the nature of the job, that you've lived in Canada. I think I would call that, I would distinguish that from Canadian experience if that's a prerequisite for that security clearance, that you have to have lived in Canada. That doesn't mean necessarily you have to have the Canadian experience. It could be totally different activities. And I'm just going through my uh, sort of legal advocacy Rolodex, as it were, to how to distinguish it. But it's a very good question, but it would seem to me that there's distinguishing features to that versus the Canadian experience, which I think ultimately the intention of that is to say, well, we're not going to prefer the fact that you did the very same thing, the accounting, bookkeeping in India, and we're not going to consider your bookkeeping experience in India as valid for Canada, right? I think that may be distinguishable.
Mhm. Okay. There is a question about, could employers be held accountable for immigration costs being claimed by a foreign employee? Pivot,
On
pivot there.
that, all I can tell you, okay, I'm no immigration specialist whatsoever. I couldn't say that like any louder. I proclaim that loudly.
Mhm.
The LMIA, though, comes up anecdotally all the time, right? The labor market impact assessment, right? That employers have to undertake. And there's clear limitations on that in terms of chargebacks to the employees, right? That you can't charge back for a variety of the costs that the employer incurs in pursuing the LMIA. So I can just tell you in that context, yes, there are significant prohibitions on the employers as it relates to clawing back costs from that employee. Beyond that, using the American reference, I'm pleading the fifth.
All right. I'm just browsing through to see if there was any more questions. Um, there is a question regarding vacation pay. Um, oh, I think we talked about that one. Lots. Um,
You're trying to save me, Natalie, till 2 o'clock, right? Eastern Standard Time.
how does vacation pay and vacationable earnings work if a full-time employee continues to receive their regular salary pay while on vacation instead of receiving the 4% vacation pay?
Well, that's fine because they will have received that, so that's fine. There's not a problem. But the problem with that is, and that's a good question because employers understandably say, well, we're just paying them through their vacation period, and so well, there's nothing to talk about. Well, yeah, but what if they got commissions over and above that?
Mhm.
So paying them their base salary through that vacation period, right, doesn't include maybe commissions or bonus or what have you, right? That they're entitled to have their vacation pay calculated on that, right? So you've got to make sure you reconcile that, right? It's not just I can continue to pay them base salary throughout that period of time, right? Because their annual earnings are more than that, right? So they're entitled to the 4%, 6% based on that. So you just have to be mindful of that. Yeah.
Okay. And just really quickly, David, I see, thank you for reminding me. There was a quick question regarding um, job posting disclosure. So if it's for a vacant position, but what if the
Mhm.
posting is to hire for a currently occupied position? Would the same rules apply in terms of transparency?
Well, I guess what's the intent is the intent to ultimately disengage with the existing employee in that position, and we're recruiting ultimately to replace that employee who's about to be disengaged from the organization. I think the intent of the legislation, I don't care what the timing is, like if there's still a current employee in that position and you're posting for that position, I think you have to identify what your intention is. Obviously say you're going to terminate that existing employee, but is it for an existing vacancy or not? The idea would be, yeah, if ultimately when you've gone through that interview process and made the selection, it will be a vacant position, then I think the intent is that's what you're supposed to do, right? Is identify if it's for, right? Because the problem the problem you've got is if you don't identify it for an existing vacancy, what kind of interest are you going to get?
Right.
And that's just bottom line, forget law. just the recruitment aspect. What kind of interest are you going to get if it's not for an existing vacancy?
Mhm.
So it's probably in the employer's interest generally to say, yeah, yes, it is, and you're not misrepresenting in any way, shape, or form. If the intent is, by the time we finish this process, the answer is yes, it will be a vacant position. I think that would be, I don't see how that's a problem because you're not misrepresenting to the candidates, which is what the sort of the idea is, right? The legislation is to be transparent with the candidates to let them know it's a position they actually could be hired into. Well, it is because you're planning as an employer to disengage with the existing employee.
Right.
By the way, that's not a good way for an employee to find out that they're about to be terminated, to find out via job posting. But that's a side issue. But yeah.
Well, just like that, we're past the 2 p.m. Time frame here. I know there's a couple other questions. You're welcome to scan this QR code and reach out to Stuart's team. They'd be happy to chat with you. Everyone will get the recording and the slides from this session before the end of the week. Um, Thank you, Stuart, so much for your time and energy this afternoon. And thanks to everyone for tuning in. We will see you on your next one and take care.
Thanks. Bye, everyone.